Check, check. Okay, good day everyone. We're now going to discuss the doctrines of the cases as penned by Justice Kagiwa in civil law. First on the list is heirs of Henry Leong versus the heirs of Miguel Madio, dated June 23, 2021, GR number 224991, and penned by Justice Kagiwa. Here are the facts of the case. The instant controversy traces its roots back to the order of award issued by the Director of Lands in favor of the petitioner Leong over the subject property located in Baguio. The award was issued in favor of Leong, who was the winning bidder in an auction sale pursuant to Commonwealth Act number 141, otherwise known as Public Land Act as amended. 4 years later, on July 29, 1964, Madio, Kiambao, Perposi, and Capiao, collectively known as the Protestants, collectively referred to this case as the Protestants, sought the cancellation of the award before the Bureau of Lands on the following grounds: that the claimants of the subject property, having been in actual and continuous open and adverse possession of the same since 1947, and that they have already built their houses thereon. Second, Leong failed to comply with the specific requirements under the award, specifically non-introduction of any improvement of the subject property since the award was the same to him. Third, they were not notified of the subject property was publicly bidded out later and later awarded to Leong. Fourth, they were the ones entitled to acquire the property by virtue of Republic Act number 730. The Bureau of Land investigated the case and looked at the merits of the claims of the Protestants in the course thereof. And in the course thereof, they found that the subject property did have some improvements thereon that were introduced by the Protestants, including a one-story house by Madio. The land investigator later submitted a report which informed, among others, that the improvements on the subject property were found to have been introduced thereon by the Protestants. The Director of Lands of Baguio then forwarded the case to the Regional Land Office of Dagupan for decision. The regional office ruled that the protest and the claim of the Protestants should be dropped, and that they vacate the premises within 60 days from the date of the receipt of the copy thereof, and that the District Land Office concerned conduct an investigation on the land on the alleged non-compliance by the applicant with the condition of the awards, and thereafter submit a report thereon. In compliance with the order of the Regional Office of Lands, the land investigator submitted a report with the following findings. First, the subject property was more suitable for residential purposes and was not needed for future public improvements. Second, Madio constructed a house thereon sometime in 1947. And third, Leong has not made any improvements thereon. On remand through his decision, the Office of the President found the DNR correctly ruled that the auction sale of the subject property violated Section 24 of Commonwealth Act number 141 and was therefore void for its failure to comply with a statutorily required notice. If found that the contrary to the requisite publication of the notice of sale in the official gazette for 6 consecutive weeks, the notice of the said auction sale was only published twice. The Office of the President agreed that with the DNR holding that the respondent Matthew was in actual occupation and possession of the subject land prior to the posting of the notice of auction sale. It is noted that the reports of the land investigator consistently observed that Maggio constructed a house on the subject property in 1947, or 10 years prior to the auction sale in 1931, 1957. It affirmed that Maggio's qualification was sufficiently established by the fact that he is the actual occupant of the subject property. He has constructed his house thereon, and he is the owner. He is not the owner of any other property in Baguio. Petitioner Leung assailed the Office of the President's decision and resolution via petition for review under Rule 43. The Court of Appeals affirmed the decision of the Office of the President and held that the respondent was indeed a party who was able to prove compliance with the requirements of the Republic Act No. 730. Factual consideration relating to the lands of the public domain properly rests within the administrative competence of the Director of Land of the DNR. And finally, findings of the fact of administrative agencies and quasi-judicial bodies which has acquired expertise because of their jurisdiction are confined to the specific matters and are accorded respect, if not finality, by the courts. The issue of this case is whether or not the CA or Court of Appeals erred in affirming the decision of the Office of the President, which, among others, first found that the auction sale over the subject property was void, and second, deemed that the July 13, 1967 order of the Regional Director of Land has not yet been final and executory. The ruling. Now, the Supreme Court here finds that the central question posed by the petition has already been correctly and consistently ruled by the DNR, the Office of the President, and the CA. After careful study of the allegations and the records of this case, the court is persuaded to respect and uphold the said uniform resolution as no sufficient ground is appreciable to disturb them. According to Section 24, Commonwealth Act No. 141, the Director of Land shall announce the sale thereof by publishing the proper notice once a week for 6 consecutive weeks in the Official Gazette and two newspapers, one published in Manila and the other published in the municipality or the province where the lands are located, or in a neighboring province, and the same notice shall be posted on the bulletin board of the Bureau of Lands in Manila, and in the most conspicuous place, the provincial building and the municipal building of the province and municipality respectively, where the land is located. The court finds that the notice of the public auction sale of the subject property in the instant case is wanting. As carefully noted by the DNR 1992 decision, there is no showing that the notice of sale was posted in conspicuous places in the provincial building or in the municipal building of the province or municipality where the subject property is located. Furthermore, as observed by the Office of the President, contrary to the requisite publication of the notice of sale of the Official Gazette of 6 consecutive weeks, the notice of the said auction sale was only published twice. These irregularities in the publication of notice cannot, by any stretch, be deemed compliant with the requirement of the breadth and frequency of posting under Section 24. As a consequence, The failure to publish the notice of auction sale as statutorily required constitutes a jurisdictional defect which invalidates the auction sale of the subject property, as well as the award in favor of Jung. Second, the court also ruled that the order of the regional director of land did not become final and executory on the ground of non-service to Madio. Section 9 and 10, Rule 13 of the Rules of Court of Service of Judgment, orders and decisions find particular relevance to, with Section 9, Service of Judgment, judgment, final orders and resolutions shall be served either personally or by registered mail when a party summoned by publication has failed to appear in the action. Judgment, final order, or resolution against him shall be served upon him also by publication at the expense of the prevailing party. Section 10. Completeness of service. Personal service is completed upon actual delivery. Service of ordinary mail is complete upon expiration of 10 days after mailing unless the court otherwise provides. Service by registered mail is complete upon actual receipt by the addressee or after 5 days from the date he received the first notice of the postmaster, whichever is earlier, as consistently found by the DNR in the 1992 decision and the Office of the President decision. The records provide no proof that the proper service of the July 13, 1967 order was made to Madio. As a rule, judgments are sufficiently served when they are delivered personally or through registered mail to the counsel of record, or by leaving them in the office of his clerk or with a person having charge thereof. After service of a judgment or order which is not appealed nor made set of a motion for reconsideration within the prescribed 15-day period attains finality, as applied in the instant case without a valid service of the July 13, 1967 order to Madio. The same may not be considered to have become final and executory. More specifically, the period to appeal or file a motion for reconsideration could not be deemed to have commenced. Still, consequently, the same was reviewable as it was in fact reviewed by the DNR Secretary. So the doctrine on this case is that the failure to publish the notice of the auction sale as statutorily required constitutes a jurisdictional defect which invalidates the auction sale as a subject property as well as the award in favor of Jung or the plaintiff. Next, we'll look at the case of Republic versus Villacuarta. This case was decided on June 23, 2021. GR number 249953, penned by Justice Kagiwa. Melvin and Janufi met in March of 1996, where they were both studying at the Southwestern University, Cebu City. They became sweethearts, but ended their relationship in the year 2000. Thereafter, Melvin heard that Janufi began dating someone who was working near the establishment where she was then employed. For months, Melvin and Janufi did not communicate with each other. However, Janufi asked Melvin to see her. In March of 2001, Melvin visited Janufi and eventually asked her about the rumor that she was dating someone else. Janufi denied the same and insisted that no one touched her and nothing happened between her and the third party. Thus, Melvin and Janufi reconciled. In April of 2001, Melvin learned that Janufi was pregnant. Melvin was surprised and doubtful to learn that Janufi was already 1 month pregnant because they had sexual intercourse only in March of 2001. Although Melvin doubted the paternity of the child, Janufi supposedly assured him that he was the only person she had sexual intercourse with. On December 1, 2001, Janufi gave birth to a baby girl named Megan Dia, and she and Melvin then began living together. After almost 3 years, or on August 14, 2004, Melvin and Janufi finally got married. October 18, 2004, Janufi gave birth to a second child named Javen Melt during their marriage. The couple quarreled about ordinary things. Oftentimes, however, the paternity of Mejandia would come to issue. During a dinner party in 2010, Melvin and Janufi quarreled and the issue of Mejandia's paternity was brought up in the presence of their relatives. This drove Melvin to finally take a DNA test at High Precision Diagnostics. In November 2010, the results of the DNA test were released, which revealed that there was 0% probability that Melvin was the father of Mejandia. Melvin received a text message from Janufi stating that she had no intention to deceive Melvin into acknowledging paternity, but it only happened once while she was drunk, and she never thought her one-time sin would bear fruit. The message also stated that Janufi was shocked at the result of the DNA and could not believe that Melvin was not the father of Mejandia. Melvin filed a petition for annulment on the ground of fraud under Article 45, Paragraph 3 in relation to Article 46, Paragraph 2 of the Family Code. The issue in this case, whether or not the marriage should be annulled. Ruling: no. The fact do not warrant annulment under Article 45, Paragraph 3 in relation to Article 46, Paragraph 2 of the Family Code. Marriage is a special contract of permanent union between a man and a woman, entered into in accordance with law for the establishment of conjugal and family life. It is the foundation of the family, an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation. In view thereof, it may be terminated for limited grounds as prescribed by law. The state is interested in the permanency of marriage relations. The preservation of the relation is deemed essential to public welfare. The fundamental policy of the state, which regards marriage as indissoluble and sacred, being the foundation upon which a society rests, is to be continuous and strict in granting annulments of marriage. Article 45, Paragraph 3 of the Family Code provides that marriage may be annulled for any of the following causes: existing at the time of the marriage. Paragraph 3. The consent of either party was obtained by fraud unless the party afterwards, with full knowledge of the fact constituting the fraud, freely cohabitated with the other as husband and wife, as opened by Court of Appeals Justice Eduardo P. Caguioa, a member of the Civil Code Revision and Family Law Committee. Although fraud to vitiate consent has been defined by the Civil Code as insidious words and machinations which lead a party to enter into a contract without which he would not have entered into. This general definition of fraud in Civil Code is not absolutely applicable to marriage, since the subsequent article of the Code, referring to Article 86 of the Civil Code, limits the kind of fraud which will serve as grounds for annulment. Consequently, in order to annul a marriage on the ground of fraud, the fraud must consist of one of those 58 enumerated in Article 86. Article 86 is a precursor of Article 40. Article 86 of the Civil Code is the precursor of the Article 46 of the Family Code. To constitute fraud that warrants annulment under Article 46, Paragraph 2, that the wife must have been pregnant by a man other than the husband at the time of the marriage, and the wife must have fraudulently concealed the same. In this regard, the concealed pregnancy, which vitiates consent, must have existed at the time of the marriage. Justice Eduardo Caguioa explains that the essence of fraud in this case is the non-disclosure of the present pregnancy of the wife. Pregnancy must exist at the time of the celebration of the marriage. Thus, if the wife had previous relations with other men, and as a consequence of which she became pregnant or bore a child previously, the concealment thereof will not be a ground for annulling the marriage if, at the time of the marriage was celebrated, the wife was not pregnant. It is concealment of the fact of pregnancy by another man at the time of a marriage that constitute fraud as a ground for annulment. No other misrepresentation or deceit as to character, health, rank, fortune, or chastity shall constitute fraud, as will give grounds for actions for the annulment of marriage. In the instant case, the facts readily reveal that Majan Diaz was almost 3 years old when Melvin and Janufi got married on August 4, 2004. As Janufi got pregnant at the time of the marriage, and any purported fraud she may have committed to induce Melvin to marry her cannot be considered fraudulent concealment contemplated under Article 46, Paragraph 2. Indeed, the court has held that not all fraudulent acts can be invoked to annul a marriage. The circumstances of fraud under Article 45, Paragraph C are exclusive and restrictive. As Janufi's purported fraud does not squarely fall under Article 46, Paragraph 2, the same cannot serve as a ground for annulment. Even assuming that Article 46, Paragraph 2 was applicable, the court finds that Melvin failed to discharge his burden of proving that Janufi acted with bad faith and fraudulent intent with clear and convincing evidence. So the Office of the Solicitor General correctly holds that while Janufi may have misrepresented the state of her chastity prior to her and Melvin's reconciliation, it appears that she honestly believed in good faith that Majan Diaz was the child of Melvin, and as there was no bad faith on her part, she cannot be guilty of concealment. Here, the doctrine in this case is that the annulment of marriage and the bad requirement of bad faith for fraud. Article 45, Paragraph 3 of the Family Code provides that marriage may be annulled for any of the following causes existing at the time of the marriage. that the consent of the party was obtained by fraud unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabitated with the other as husband and wife. To constitute fraud that warrants annulment under Rule 46, paragraph 2, the wife must have been pregnant by a man other than the husband at the time of the marriage, and the wife must have fraudulently concealed the same.